Hello, I'm Susan Guthrie, America's Divorce Innovation Specialist, and today I'm going to continue my series of questions that are the most Googled around divorce. So today the question is, who gets to stay in the house during divorce? And usually what that really means is, can I get my spouse out of the house during the divorce? And the answer to that question is, it depends. Like so many things in the law, there is no usual set answer to this question. So, what it first comes down to is in your average case where we don't have domestic violence or some sort of a situation where one of you might have been removed from the house. So, in a domestic violence situation, um, um, most often the party who has committed the act of violence is removed from the home, and the court issues a protective order ordering that they not only not be in the house, but not have any contact with the victim going forward. But barring that extreme situation, what you more often see is two people who both have been living in what we call the marital residence with or without children, but who have been living together, who now have in some way come to the point of divorce. It's a difficult situation living with the person you're getting divorced from. And invariably, someone wants to know if they can get the other person out. And that comes up much more often. And I will tell you first, it can be difficult to do because if you both have property rights in that property, and that doesn't necessarily mean that you have your name on title, but if you have been living there, you have certain rights to continue to live there. And so there are two ways really to get the other party out. One is by court order, where you seek what we call a pendente lite, or temporary court order that one of the parties vacate the property. Or, easier and more often happening would be you come to an agreement that one of you moves out, either through mediation or through negotiation or for some reason. So now, if you're filing a motion with the court, it's usually called something along the lines of a motion for exclusive possession of the property. And what it's essentially asking is that the court order, for some stated reason or reasons, that the other party be ordered to go live somewhere else, and to give one of the parties that exclusive possession, meaning the exclusive right to reside on the property. Now, that doesn't mean that the other party cannot come on the property, but usually it would have to be either by permission of the party or under some sort of time frame that is set by the court. Very often they will give them, a certain amount of time to move out, find other lodgings, etc. Now, there needs to be a reason why you are asking the court to deprive the other person of essentially what's a property right. You're essentially saying that this person does not get the use and benefit of something that they have a legal interest in, a house. So you have to have a very good reason. And I would say the number one reason that we see would be the allegation that the situation between the two divorcing parties is so toxic that it's creating an unhealthy environment for the minor children. And that's usually where the parents are unable to control their emotional state, and there have been repeated outbursts, arguments, or negative consequences for the children. And usually there would need to be some sort of exhibited negative effect upon the children. They're not doing well in school. They're having behavioral issues, psychological issues, kids that are doing well in all ways, but mom and dad allege that they're fighting too much and what someone should have to move out. That's not always going to rise to the level, but where you have kids that are having some problems, unfortunately, the court can determine that it is in their children's best interest that one of the parents lives somewhere else. Now, a complicating factor in all of this is the cost. And a very real financial situation for many families is that it does not work financially to establish two households. So where you have a situation where a certain amount of income, whether both parties have been working or if only one of the parties is working, but there's a certain amount of income coming into that household, and it's maintaining that household. And now you need to establish two separate households or another separate household. And usually if you do have children, that separate household needs to have accommodations for the children to be with the other parent, if appropriate. And so it's usually a financial burden. So unless there are assets that you can dissipate, and the parties want to do that, so keep in mind the money that gets spent on the second household is money that is gone, and so is not subject to being divided between the two of you in the divorce. So if you had $100,000 in a bank account and 50,000 of that during the divorce gets spent on establishing a second, residence for one of you to move out to, that's $50,000 that's gone. Now that can be negotiated in a lot of ways, but I just want to point that out. So the next question that a court does have to take into consideration, except in the most dire of situations where there's violence or harm, demonstrable harm to the children, is whether it's even feasible to have one of the parties move out. But if it is, then courts will order, again, within a certain time frame, that one of the parties establish a secondary household. At that time, the court is almost always going to establish some sort of parenting plan as well that will go into effect when the other party moves out, when that parent moves out, because now the kids are going to have to shuttle between the two households. So that is usually a part and parcel of the motion for exclusive possession, whether you ask for that or not. The other party who's being asked to move out will ask for a parenting plan in most cases. So that's difficult. What judges do in some cases where they can't order someone to move out, or they don't feel the situation rises to the level of needing to make one of the parties move out, they still can impose certain orders on the parties regarding their behavior, regarding parties vacating the house at certain times during the day, not having conflict, not exhibiting argumentative behavior or denigrating the other parent in front of the children or in their hearing. There's all kinds of what I call prescribed good behavior that a judge can put into an order. It's hard to enforce because the only way that there is enforceability is when someone violates those court orders. So the barn door is already open, but then they can put in place more strict, guidelines for that parent if they violate those court orders. So the judge will put good behavior often into the court orders in any event. Usually those good behavior orders go both ways, though. It will say neither of the parties shall denigrate the other in front of the children or in their hearing. It won't say dad won't or mom won't. So those are the sort of things that you can expect. Now, putting aside court proceedings, exclusive possession, it is not that uncommon that parties will negotiate a move out during the pendency of the action. In mediation, we do this all the time, especially where the parties are in agreement that they both want to start moving forward, and it suits them in some way to start working toward getting out of the limbo of divorce and getting to the point where they can start living their new lives. So they will make interim agreements about one of the parties moving out, receiving a certain amount of money in order to do that, that may then be credited to their eventual property distribution, with some discount for the fact that they, in good faith, did that. There's a lot that can be worked out by agreement, and by far, and I tell this to every client who says, how do I get them out? By far, that is the most reasonable and most certain way that you can start living separately and have at least some peace in your home and privacy in your home. And they get the same thing. They get some peace and privacy in their home. So it's not one of those things that most attorneys are opposed to if the appropriate parenting plan and agreements can be put in place. So I do urge you, if that is something that you want to achieve is that you consider mediating the issue and or negotiating that issue with your spouse by identifying, what can you incentivize them with to get them to move out? Because what you get is your peace of mind and privacy, but you're going to have to give something to get that. So always keep that in mind. So thank you for joining me today, and I will be continuing this series. We have some more really great questions that people Google around divorce. So have a great day, and I'll see you next week.